Good morning, everyone. On behalf of the panelists this morning, I'd like to welcome you to the session From Aunties and Uncles to Arbitrators, Managing Community Clients Without Breaking Ethical Rules. I would like to start with actually the panel introducing themselves, and then I'll briefly describe how the panel will work after that. We are missing one of the speakers, so do bear with us, but we thought just to be on time, we will start with Judge Shashi. If you could do a quick introduction, that would be great, and we'll go down the line.
I don't think this is on, but it's okay.
Are you cannot? Can you hear us or no?
All right. Hey. All right. Good morning. My name is Shashi Kewalramani. I am an arbitrator and mediator at JAMS. Until 8 months ago, I joined JAMS 8 months ago. Prior to that, I was a U.S. magistrate judge in the Central District of California, where I handled everything because that's what we did. And we actually dealt with quite a few of these issues as they arose in conflicts issues that would arise and motions that would be presented. So, pleasure to be here. I'm up.
Sorry, I was running on Indian Standard Time. My name is Subodh Chandra. I'm a civil rights lawyer. For the last 29 years, I was based in Cleveland, Ohio, after a career as a federal prosecutor, large firm litigator, city attorney for the city of Cleveland. But I recently moved to Oakland, where I was admitted to practice law in California 29 years ago, to expand my practice to California. So we do plaintiff civil rights work, First Amendment, police misconduct, employment discrimination, retaliation, whistleblower cases, those sorts of things. And ethical issues come up all the time, and I've been an amateur ethicist. I've taught ethics at Case Western Reserve Law School, and am really looking forward to today's discussion. Thank you.
Oh. Hi, everyone. My name is Sidra Zahir. I'm a partner with Rosingpot and Strobine. The majority of my practice involves representing attorneys and law firms in adversarial matters, whether it's straight bar complaints or litigation. I also advise law firms and attorneys on issues like information governance, cyber issues, e-discovery, privacy. Yep.
And hello, everyone. My name is Emil Ali. I'm a partner at a firm, McCabe & Ali. I focus my practice on representing lawyers and law firms in ethics issues and the law of lawyering, so everything from lateral transitions to ethics and conflicts matters.
Good morning, everyone. My name is Sabera Choudhury. I'm a managing director with BRG, based in Chicago. BRG is a global consulting firm where we provide expert witness and investigation services. We have about 2,000 professionals. I personally specialize in investigations on a variety of topics, everything from financial fraud, accounting malpractice, legal malpractice, asset tracing. I do also have experience in commercial litigation, quantification of damages, lost profits, evaluation issues too. BRG is very excited to be sponsoring SABA this year. And on a personal note, I'm very excited to be on my first panel with all South Asian speakers. So on that note, I'd like to just give you an overview of how we will be, what we'll be doing during this panel. We will be covering certain ABA rules as well as relevant rulings and guidance through hypotheticals. These hypotheticals are things that one or more of our panelists may have experienced in some form or shape during their career. But I also want to just reiterate these are hypotheticals that isn't just exclusive to our community. It could be something that you will deal with through your own network. So once we have 4 hypotheticals, we would like this panel to be as interactive as possible. So after we present each panel and the panelists talk about it, we will open up the floor for you guys to ask questions as we go along. So the first hypothetical we'll be addressing, you'll see on the screen, but I'll also read out. You're a corporate litigator, a well-respected community elder calls you. Better, I know you deal with finding money. My niece is going through a nasty divorce and her husband is hiding assets for sure. I told her you would fix this. I have her on the other line right now. I'm patching her right in so you can tell her what to do. So this is a hypothetical. I'd like to hand it over to Emil to address how we would address this and the relevant rules and negation items.
All right, so thanks so much. So obviously this is an ethics CLE, so we have to talk about those boring, pesky ethics rules. So I'm going to try to introduce to you a couple ideas, and I'm sure all of you can probably figure out what the problem is. How many of you are family law lawyers? Okay, so with the exception of the two of you, would everyone agree that we're all incompetent to handle a family law matter? Would everyone agree? Okay, so because I am clear, I'm an ethics lawyer. I am clearly incompetent to deal with anything related to this, and I'm not afraid to admit that. But the question is, how do we impart that to this auntie or uncle, to this elder that's telling us? So, I can tell you, educated lawyers, I can say, hey, rule 1.1, competence. If you're not competent, don't try to provide these services. But beyond that, we have to think about things like confidentiality. We all have to be able to understand confidentiality, privilege, work product protection. But how do we explain that to somebody else? So we definitely want to be able to impart to them the issues related to, hey, I can't handle this case. It's just not in my remit. Second, if you're on the phone with this potential client, even if it was in my remit, would I be breaching my duties to the client because of that breach of confidentiality? And then on top of that, am I creating an inadvertent attorney-client relationship under, for example, Rule 1.18? Because I'm not taking precautions to not try to avoid that. So, one of the things that I can talk to would be like 1.1. This is a scenario that probably happens to me about once a month, where I get a call from somebody that's like, hey, can you please talk to so-and-so? They may not say, hey, let me patch them in on the other line, but they'll definitely say, please reach out to them. And many times, I simply tell them, I'm sorry, that's just not my area. But it leaves me, whether it's culturally or just as a helpful person that I want to be, it leaves me in a predicament. So what's something that you could do to tell them? Well, I want to give you an analogy that I give. Many South Asians are physicians, and I think sometimes it's easier to understand it from that lens. Would you, auntie or uncle, if you needed brain surgery, would you go to a dermatologist to ask them for help? Probably not, right? So why are you asking me, an ethics attorney, for help? And obviously not everyone knows that, but sometimes helping them through analogy rather than say, hey, this is the ethics rule, is sometimes really helpful. But I'd love to hear from my fellow panelists about examples of, how do you explain to them confidentiality or privilege? How do you define these terms?
Yeah, sorry, do you want me to, I'll go ahead. I think, I was actually talking to the other panelists about this earlier. I feel like it's a really difficult concept to explain, especially to elders. I've definitely had situations where my mom has been like, beta, what privilege with me? So, kind of trying to navigate that, it's hard. So how I explained it to her is, Mom, anything that I communicate to a client in furtherance of their representation is privileged, meaning, I am not at liberty to disclose it. And it's privileged, as to anyone, whether you're I would love to tell you if I could, but I just cannot. And this privilege extends to basically anyone other than my client. And it's not personal, but I could get in serious trouble with the bar for even disclosing this information to you, and I could lose my license. So really, that kind of resonates a lot, definitely, I think, with parents and elders, being like, I could get in serious trouble with the bar. So that's kind of my fallback. I immediately, if they're pushing on it, I'm like, I really cannot do this. This could become a state bar issue. So that's kind of one strategy that I use.
I guess my response oftentimes to these types of questions is like, I don't know. It's like, what can we do? It's like, I don't know. That's the honest answer. And they're like, what do you mean you don't know? It's like, and you've got to be comfortable saying, I don't know. And that's fine. And what are they going to say? It's like, of course you do. It's like, you keep repeating it. If it's true, and then say but let me try and find you, the best you can do is let me try and find you somebody in the community that is a good lawyer. Just like anybody else, it's like, who would an attorney, I always ask doctors, which doctor would you go see? that's the doctor I want to go see. Not the most popular one, not the one that's got the longest thing. It's like, where would you go? And I think the benefit we can say is like, but let me use my expertise and knowledge about the community and the legal community to direct you to a good person.
It usually doesn't take me very long to convince people that I'm an idiot. So that's really the approach. The analogy about medicine, similarly on privilege, you can say, listen, this is like HIPAA. This is like HIPAA. I can't talk about this. But really, increasingly, what we'll do in these scenarios is, because we get asked a lot about domestic relations or street crime, criminal defense, or things along those nature, we have a list of people that we'll refer them to. Now, people are very cost conscious, understandably, and as a plaintiff's civil rights lawyer, I've come to learn that increasingly clients believe that they should have our services for free. They're just entitled to them. And so in those scenarios, when you start referring, sometimes you get somebody reacting very upset because they were looking for free consultation, free advice. But when you emphasize, that's just not something I know about. That's just not something I know about. I didn't study that. I didn't take that class. I don't know anything. And you have to persist at that and say, I'm really out of my depth here. I just don't know. I just don't know. I just don't know. And then give them the alternatives. Then usually you can resolve the problem. But not always. It can be challenging.
And I think from my perspective...
Can you move the mic over?
Yeah, thank you. Do let us know if you can't hear us, by the way. From my perspective, our community is pretty small. Everyone thinks they know what we do for a living. This is something, particularly this whole issue of asset tracing, or I know you found money for other people. When I get that call, the first thing I say is listen, I appreciate the situation you're in, but I need to refer you to an attorney. I'm not a lawyer. I work with lawyers. It's incredibly important to maintain privilege, and so that's where the discussion of what does privilege mean? It gets complicated, right? The privilege only it flows down to me once they retain attorneys. So the first thing I would say is, you need to find an attorney. Here are some people I would suggest, similar to what you were saying, and explain to them, while I'm sympathetic and I really suggest you hire lawyers, and then we can have a discussion. And then obviously, if it's individuals we know, from our perspective of being experts, we may have to recuse ourselves anyway because we may know two parties. And so there's that discussion too. It's not just about the privilege, but hey, in the event you need to retain us, or your attorneys need to retain us, I may not be the person that can do this investigation for you, but I'll find you the best person. And so from my perspective, that's the conversation that we would have. I did want to ask Emil in particular just to talk about the Minnesota Supreme Court case on this issue and the Oregon guidance as well.
Sure, thank you for that. So one of the issues that we haven't yet touched on in this hypothetical, right? We talked about competence, confidentiality, and all that, but we didn't talk about UPL. How many of you are licensed in every state or territory in the US, right? None of us. So how do we know? We all assume, by the way, family law is a state law, so it varies from California to Nevada to Oregon to Washington, so we need to know what law applies, where we need to be licensed. So there's a very interesting case out of Minnesota that involved a Colorado licensed attorney that decided to represent his in-laws in Minnesota in a dispute with their HOA. Opposing counsel for the HOA said, hey, you're not licensed here, and then made good on his threat to ultimately submit a grievance to the Minnesota bar. What did they do? They gave him a private admonition. So it's still disciplinary, but private where his name is not published. But why? A lot of people think, especially now post-COVID, we're like, well, if we don't go to Minnesota, if we just do the work from Colorado, it's probably okay. And the answer is probably not. So you still need to think about whether UPL issues may apply as well. So it's not only, am I competent or not, but am I licensed in the appropriate jurisdiction? So that's giving one side. So on one side, we have Minnesota that's basically saying, don't send demand letters from your house in Colorado because that would be UPL. On the other hand, we have Oregon. So I used to be on Oregon's UPL committee, and we have some great FAQs on our website. So this is just general helpful FAQs, but there's also an FAQ that says simply sending a demand letter from outside of Oregon is not UPL in Oregon. So that leads to a lot more confusion where every state is going to analyze it differently. In California, we have a case called Beerbauer that, for New York attorneys that were practicing California law and dealing with the California arbitration, were not entitled to fees. And that's a very, very scary case. So there's a lot of different guidance out there, and that alone leads to a lot of confusion.
The one thing I wanted to ask the panel is, how do you explain the difference between privilege and versus confidential information to someone who's, not an attorney, to a layperson?
Sure. So, well, I think firstly, there's a really important distinction between privilege and confidentiality. Attorney-client privilege, it's governed by the evidence code, and it's a lot more limited to communications with your client in the furtherance of representation. Confidentiality can essentially cover basically everything to do with the representation, even if it's public information that you learned during the course of the representation, that's still confidential. So I think that, it's really important to kind of remember, it's easy to think, the privilege is something that we always think of. We're kind of trained to think of it immediately, oh, this is privilege. But confidentiality, I think it's a concept that it's a lot harder for people to get their mind around. But, it really is basically everything that you learned, in connection with that representation is confidential. And you have, I think it's Rule 1.6, obligation not to disclose any confidential information without your client's consent.
We good? I'd like to open it up to the floor to see if you have any questions on this particular hypothetical, anything we've discussed so far. We have a question in the front.
Yeah, so I was thinking about what you just said in terms of what privilege would mean, right? That even if you are within the scope of your expertise, there is a difficult angle to this, which is that the concept of confidentiality within the community is a little different. Right, and so even if you are representing someone, and if you are one of the two family lawyers in the room, which I didn't even get your number that worshiper, but it may not be a good idea because the risk is that, oh yes, my daughter or my son is representing so and so, right? Because your parents are proud of you when they talk about it, or your uncle or whatever gets very excited, and so the concept of confidentiality doesn't maybe culturally translate as well. So I'm curious how you do that when you are within the scope of your expertise. Is it ever just like, you know what, I could do this, but it's not a good idea because you should have a professional distance from the person handling your family law issue, your lease, your negotiation, whatever.
Emil, did you want to start? And then I've got
Sure.
something to add.
I have a lot to say. I guess on this particular issue, I would say, please don't tell your parents who you're representing because that's a violation of Rule 1.6. So, and I have a hot take here because many people don't fully understand this, but you should not even be, so 1.6 is expansive, period. Anything essentially learned during the representation is covered by 1.6, especially if it could impact your client. So, the fact that Johnny Cochran represented O.J. Simpson, he could, well, he's not alive anymore, but he could put that on his firm bio. The fact that I represented so-and-so, whether it's in a public case or a private case, I cannot put that on my firm's website because that is not generally known. ABA Formal Opinion 481 and soon to be in the comments to Rule 1.6. It's a new comment that's going to be probably approved this August, which talks about that generally known standard. So if something is not generally known, just because it's public does not mean that you should be sharing it with anyone. So one, don't tell your parent who you're representing because that's not covered by any confidentiality. And two, even if it is public, it may still not be appropriate to share it. And I think that's a really, really important distinction.
So I have a question for you. When you say public, you mean like a court filing with your name on it? That's
That's not generally known, correct. It is public. It's available in the court records, but just because something is public does not mean your duties under Rule 1.6 don't apply. Why? Because it could be embarrassing to that person that it comes out that, yeah, they were arrested for a DUI, you're a criminal defense attorney, you represented them, you got them off with a wet reckless in California. Great, you did a great job, but they don't want everyone to know, they don't want to be listed on your firm bio, they don't want you telling people.
I'm just changing the hypothetical just a tad because this happened to me personally, but I helped out one of my parents' friends, and they recommended me and whatever, and I didn't discuss it at all, obviously, with my parents. However, they were like thrilled, like your daughter, and she took this testimony, and blah, blah. And like it was so mortifying, and to this day, that uncle literally was like, she's the best lawyer in the whole town. And I'm like, first of all, it was like a small matter, like red car, blue car situation. And so he talks about me like I'm really Johnny Cochran, and it's wild because he shared more of that information with my parents. Like he just assumed because they introduced us and said like, yes, she is a lawyer, go on. And it puts you in a weird spot from a privilege perspective because he's already waived that. Not only has he waived that, he's like having seminars about it.
Emil.
I was like, represent you? Like, I don't know.
Yeah.
I had a very similar situation. So my wife's a university academic, and one of her colleagues asked me to help him on a university disciplinary issue. I didn't tell my wife. And, it was resolved. It was fairly small, actually. It was resolved fairly easily, but I never mentioned it to anybody. And when we were having, breakfast with this friend, who was a friend of colleague of my wife, he brought it up. And it was kind of a surprise because my wife was surprised, and she was kind of like, why didn't you tell me about this? So later on I explained to her, but he was also very surprised that I had never even mentioned it to him. So I had to, but it was a little bit of a source of tension between me and my wife because she was like, how could you not tell me, So you really do need to explain to them. I mean, and I told them, look, this is your story, this is your privilege. I wouldn't, I wouldn't disclose it to anybody. I don't even know if you want me to disclose it to anybody. But he kind of just assumed that, oh, you must. So, yeah, you really do need to explain to your family members and stuff all the issues and why it's important. If you don't, it can kind of break the relationship.
So maybe setting expectations with your client and your family is helpful, is saying, hey, I love the fact that you're saying all these great things about me, but I'm also just worried about your privilege. Or, hey, spouse, hey, parents, I understand that you've referred somebody to me or blah, 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 but I can't share anything with you.
I did want to mention something, and I appreciate you talking about the upcoming changes on the ABA rules, because I actually am now seeing a tension if there's going to be a broad interpretation of confidentiality for even matters that are publicly filed. I see that as coming into conflict with Rule 5.6 of the Rules of Professional Conduct. Rule 5.6, which probably none of us have thought about, says that we can't compromise our right to practice law as part of a settlement. And you think, well, okay, I'd never do that. But there are variations factually that occur where we've had, because we do a lot of high-profile civil rights cases, we will have defendants, sometimes public entities, sometimes private entities, that will try to extract from the settlement agreement an agreement that the lawyers will not say anything about this matter in the future. Now, there are ethics opinions from bar associations all around the country, state bars, at least 11 to 13. I got an essay on this on our website that say that if you agree to that, if you sign off on that as a lawyer, you're agreeing to compromise your right to practice law. And in fact, Ohio and a couple of other states now have an ethics opinion that says if your client insists on that to get the deal done because the other side is insisting on it, you have an obligation to withdraw. Why? Because advertising what we do talking about what we do, marketing what we do, is a fundamental part of the practice of law. And so when something is a matter of public record and a matter of court record, that's what these opinions say, we are allowed to talk about it. So there's a tension between this obligation on confidentiality and privilege on the one hand, and not compromising our ability to practice law and tell people what we do. For those of you who are in large firms with large institutional clients, this isn't an issue because you inherit your work from the partners before you in the firm. But for us, as entrepreneurial plaintiff side lawyers, having people come to our website through search engine optimization, increasingly AI optimization, hearing the stories on our website, on our news section about the kinds of cases we've handled, sexual harassment, First Amendment, police misconduct, that storytelling about these high-profile public filings, sometimes not high profile, but they become high profile because we've put the stories out there. That is a part of our marketing, and so I see a tension emerging. I think a lot of this is about exercising good judgment. You know, right, which matters are sort of supposed to be low key, and I think setting those expectations early is important. One last point I'll make is that in the matters that we are going to put up on our website, we have a conversation with clients about that, just, make sure there's no objection that we'll be doing this. But at the same time, we say, you have no veto power, you have no control over the content of our website, and that's for your own protection. The website itself has a disclaimer. We are solely responsible for all of the content on our website to try to protect clients against defamation claims or something. It's like they had nothing to do with what gets published out there, nothing whatsoever to do. That's our own writing, that's our own reporting on what we're working on. So these rules can wind up in tension. Just be careful you don't, run severely afoul of one of them.
Yeah, I have a nuanced question on this topic. And by the way, I have hundreds of stories of people coming up to my spouse. He knows privilege, he's the one. But in terms of, we get a lot of go-betweens, like the friend who calls you for the friend.
Yeah.
And we've referred them to someone, and then they have a problem with that lawyer. And so then the friend comes back in to manage the relationship with the referral source, like about fees or responsiveness. And I'm not supposed, it's not my case. It's somebody else's case. It's not, the friend is not the client. What are the ethics rules about us getting, involved in managing lawyer-client relationship? When all you've done is refer.
So we're actually, I think, going to touch on that in hypothetical 2, so maybe we can jump into that.
Yes, it's a good segue. So hypothetical 2, your aunt calls you frantically. Her niece-in-law, a Canadian citizen born in India, has an H-1B extension on hold. You're a real estate attorney. Your aunt demands, she's family now, so you have to fix this. Look, don't forget she's my daughter-in-law's sister. You have to help, and please don't embarrass me by saying no.
Raise of hands, please. How
Yes.
many people
How
have
many
had
people-
similar conversations?
Can we just have a standing objection that your hypotheticals are not hypotheticals?
I did say one or two of us on the panelists may have actually experienced this or something similar without going into any more specifics, but yes. So I am going to toss this over to Sidra to kick us off the discussion.
Yeah.
Okay.
So I think there's a couple of things to kind of keep in mind in this hypothetical. I mean, the first one is obviously the privilege issue that we kind of touched upon earlier. Having the, the aunt on the phone and having this conversation with the client at the same time, there's a privilege waiver there because you have a third party that you're not representing on the call. So that's kind of the first thing that I would keep in mind. The other thing that I think is important to keep in mind is who's going to pay for, if this representation. If you do represent, this niece, is your aunt going to be paying for it? And then the question comes up, what are your obligations when a third party is paying for, your representation of a client? And so I think there's, it's important to keep in mind there that, you can't accept third-party compensation if it is in any way going to interfere with your representation of the client. And then also the client must give informed consent to this third party, paying for the representation. Yeah, and I think that there's a lot to unpack in this hypothetical. So I'll pass it back to Emil, or I'm not sure if anybody else wants to.
Yeah, I guess one thing I'll say is, you know, speaking of, like, you were talking about what Rule 1.8 and third-party payments, one, like, just a frame of mind to understand is, in most jurisdictions, you can't really share fees with non-lawyers. Like, technically right now, Arizona is the exception. They've abrogated 5.4. But when it comes to, you know, Rule 1.8F, it says you must get informed consent. It doesn't say confirmed in writing, but I would highly recommend that if you are going to get any sort of informed consent, that it be confirmed in writing. But the idea is we're not allowing other people to sell our legal services under Rule 1.8, but we're also not allowing anyone else under Rule 5.4 to control or direct our legal services, right? We don't want people to tell us what to do. So we don't want this auntie to say, well, you know, make sure that the H-1B says this, or make sure that, you know, we get her an OPT and an F-1 instead of the H-1 because, you know, we need this. We don't want anyone else. We want to make sure that as lawyers we do what we're supposed to do that's best for our client, right? Within the bounds of the law, within what our remit is, what our competence level is.
I just want to add something really quick to this. So this comes up a lot in our practice where let's use the example of a father approaches us because his daughter has experienced a sexual assault and sexual harassment, but the daughter isn't a minor, the daughter is an adult. Or a sister comes to us. And so we will really assess at the beginning because you know, you've got the narrative, the factual narrative coming from the dad, and first of all, that's coming filtered. So you're going to have to go directly to the source. You're going to have to do it in a confidential setting. You're going to have to make sure that there's space for your actual client that you're going to be representing to really tell you the truth and tell you everything, including the details that might be embarrassing to share in front of dad. So you have to really use good judgment about that. But then sometimes, I have a case right now involving a firefighter, sexual assault and sexual harassment survivor in an employment situation where the trauma experienced by the survivor is so severe that at least, especially in the early stages of the litigation, they really needed help. And so the older sister, who's very close to the client, then after informed consent discussion with the client, we all agreed that the sister would be an agent of the sister client, and we wrote that into the engagement agreement. This person is your appointed agent, privileged. Now, whether we have to fight over this later with the court is a whole other issue, right? But I thought it was all legit. This person is going to be your agent. We are authorized to speak with them. Discussions with them and joint discussions with them will be considered privileged. All of that is memorialized in writing. But there's also a conflict section, you know, there that talks about a waiver of conflict with respect to that, and that if there is a conflict and you decide to, you know, unappoint this person as an agent, that's fine. We will continue the representation with you. So there are times where you need, I don't know how Emil feels about this, but there are times where I feel like I need to bring someone else, a parent or someone, into the fold to help, but I have to stay centered as to who the client is and who's really going to call the shots eventually. And if a conflict emerges, and we've seen it emerge, you know, what do you do in those circumstances? But you got to be really careful about it.
I mean, I will say that I can 100% appreciate that. Remember, I represent lawyers, and many times I am often talking to the lawyer's spouse at some point when something bad is going on. And, you know, there's privilege issues there, but sometimes you just got to do it. You got to have that conversation and say, listen, you're going through something, and I need to make sure that you have a support system. And, you know, let's talk to who that support system is. And, you know, sometimes it's talking a little about legal strategy. Like, what's it going to, like, we're going to go to trial. These next 9 months or 1 year are going to be horrendous. Here's what you should expect, and here's what I need you to make sure that this person goes to the LAP program. So I think it's key, but it's also just understanding those confines, making sure you have a discussion with your client before you involve.
I have a quick question for you on that score, though, because I'm glad you brought up the spouse situation. We've had to have, you know, that involvement in those conversations many times, particularly related to issues of emotional distress and strategy and those kinds of things. I have yet, to my surprise, I have yet to have opposing counsel drill down in depositions and try to find out when the spouse was in meetings with the lawyers and try to say that's a waiver of privilege and all of that. I think in part, because my view of it is, well, there's also spousal privilege attaching to those conversations, so I think we're generally safe, but I try to avoid it as much as possible or memorialize in writing that the scope. I'm sorry, yeah. Please,
right,
now,
I mean,
now we need to hear from the judge.
I mean, but that's a trial privilege, and it's not a discovery privilege. So there's two different things about that. There's spousal immunity, and then there's spousal privilege. It's two different things. So I think about it in the criminal context. When let's say you got a 21-year-old kid, right? 21-year-old kid, parents are paying for the fees. Let's say they got a DUI. They come in, both of them come in, and the mom wants to know what happened. What are you going to do? That, to me, were the tough situations, particularly in criminal cases where the family is deeply involved. And what advice would you give to criminal defense attorneys to say, like, look, I can't tell you, I need to hear from your kid what went down, and alone, and I can't tell you what went down.
So yeah, let me address that. So that is a law school hypothetical. So. Okay. Parent and child go to a lawyer because the child, we'll call kid,
adult,
child, adult, got a DUI. Okay, so if they go to they go to this lawyer and it has to do with this DUI, what does the child want? The adult child, they want to get out of it no matter what, but they also don't have the money to pay for it. The parents have the money. 1.8F conflict. But what happens when the parent is like, you know what? I want to make sure my kid spends the night in jail so that they learn their lesson. That's tough South Asian parenting right there, right?
That's not just South Asian. I've seen it across. Yeah. I've seen it across, like kids in Newport, kids in Laguna. I've seen this. Yeah.
So I think that's a really, really important example of where that conflict lies. So what would I do? Exactly what you said. I would put that adult child in a room and say, listen, you are my client. And tell the parents ahead of time, I need to talk to this person individually because that is my ethical duty. Then you go to them and you talk to them and say, listen, you are my client. You will be my client. But your parents want to pay for this engagement. I will do that. Ultimately, you're still responsible for it, blah, blah, blah. However, the next step is how they will interfere with our relationship. I do not want them to interfere. However, in my experience, I think if I share certain information with them, I think we'll reach a happy medium. This is what that will be. But at any point, if you feel that you do not want me to share the information with them, you have to let me know, and I will act accordingly. So right now, I will thread that needle very carefully.
I asked this, when I was a prosecutor, I had a criminal defendant, he took the stand, and I said, when you were meeting with your counsel, who else was in the room?
Yeah.
I mean, that's just, I wanted to know who else was in the room. Turns out his wife was in the room.
Yeah.
Objection. It was like half-day thing. It was a mess. And because the spousal privilege, and that's how from experience you'd learn, it's like, okay, well, that's a discovery privilege. It's not a trial, or the trial privilege, not a discovery privilege. So the question is, I guess for me, from an advice is then you should make clear to the person fronting the fees, particularly in a child or spouse situation, that person is my client. I can't tell you everything. And then I usually used to give a warning. It's like, if I do tell you this with you in here, the prosecutor's going to find out.
Could
Judge,
I just ask?
Could he just? I'm
ahead.
just asking you to spell out a little bit more on the distinction on the discovery versus trial privilege as to, do you believe, it's one thing to say who else was in the room and then just find out. Do you believe that the content of that discussion is fully discoverable at that point if the spouse is in the room talking to the attorney?
A waiver's a waiver. As a prosecutor, a waiver's a waiver. It's like you talking loudly in a park.
What about if it's memorialized as part of the engagement agreement that the scope of the privilege will attend to that person as an agent? Do you think you're on safer ground?
I don't know. I have never researched that issue of an agent situation in that sort of context. It's different in a corporate context, right? Because the corporation and then the agents are working in that I've seen research, but I've never seen it researched in a family situation.
Yeah, so we're going to talk about 1.13 with the next hypo, but just because it's spelled out in the engagement letter does not necessarily change the way privilege is going to be analyzed by the courts, right? You can't, so there was a Supreme Court case that got pulled back. They said it was improvidently granted, but it was called in re grand jury. It was going to be able to harmonize this zone of interest privilege issue, but we don't. There's currently a circuit split on this particular issue, at least at the federal level, when it comes to what that zone of interest might be. But when it's a translator, that's very clear, right? When it's a minor, it's very clear. But when it's an adult and you're involving third parties, not necessarily clear.
And yet our lives, the practical nature of our lives is you have to involve people.
Yeah.
So I was just going to ask, I'm not sure if we may have covered it already, but in the issue that we discussed about the DUI, and let's say there was a review of telephone danger or whatever, cell phone danger, but there's other potential allegations that this individual may face that is probably, much more severe than a DUI. Then what do? You do tell the parents?
I don't think you can.
Yeah, it's Rule 1.6, protecting
Right.
information.
Yeah.
No.
But remember, 1.6 can be waived by the client with informed consent. So theoretically, it can be waived. Privilege is a little bit different because just because you shared confidential information, that doesn't necessarily mean a waiver of privilege. 1.6 is broader than privilege and broader than work product protection. So.
Okay. Any questions from the audience?
I still don't understand the difference between confidential and privilege. I'm just
the
like,
judge.
dude, I can't tell you anything, and because privilege is supposed to be analyzed very narrowly.
Yes.
It is a restrictive way of not disclosing stuff. Similar with attorney work product. There's core attorney work product. There's non-core attorney work product. Right? But if a client tells me, I just tell it's privilege. Well, is it no? It's like I don't know. It's privilege. I'm not talking. Yeah. And I would always advise my client to say that. It's like, I don't know. Talk to my lawyer.
Yeah. If it's privileged, it's probably confidential too, but just because it's confidential does not mean it's privileged.
Yeah.
That's the way I look at it. And for you to not tell everyone.
Judge Gandhi thoughts? Am I the only one? Yeah, that's right.
Protects communications, only the communications, not the underlying facts or content, which might wind up in public.
Yeah.
So, if my client tells me, the light was red when I went through the intersection, obviously it's telling to them that communication. It can't be what did you tell your lawyer about the light being green or red? But obviously the underlying facts are anybody.
That's motion practice. That's where it comes down to. That's exactly the motions we would see, right? One side is saying it's not advice, it's not attorney-client privilege. It is the underlying facts. But as a practitioner, I don't want to even get close to that. I mean, that's going to have to be a fight down the road.
But I think even more fundamentally than that is anything that a client provides to you in the furtherance of your representation and seeking that. They have no relationship with you outside of that. So, but for this relationship, they would never just randomly send you all their text messages. They would never tell you information about the fight they got into yesterday.
And that's the opposition in the motion.
Yeah.
That's right.
Can you comment on the scope of who is reasonably necessary or can be
Yeah,
necessary
that's a good point.
to be at a meeting? Because this hypothetical it's clear, Aunties are reasonably necessary, but in a family partnership dispute, it's a family affair, kids involved, things like that. So what are kind of the outer parameters? An interpreter's easy, I get that, but what about the outer parameters of what's reasonably necessary?
I don't know.
That's a really hard question. Just because reasonable is obviously, that's very depending on the situation. I think that if I had to define it, I would basically think of someone that basically is integral to the dispute. Like that's how I would describe it. Like, someone that basically is completely so involved and ingrained in the facts that you literally can't represent your client without that person. I tend to take an extremely narrow approach to this. But again, I think lots of attorneys, Emil might have a different kind of position on this. I'm more conservative when it comes to confidentiality, privilege, that's probably a product of my practice area. But, I think that really you have to how I think of it is, would I be able to explain to a court why this should still be privileged? That's how I kind of approach this. Can I justify this and why this is still privileged if I have to at some point, essentially?
And Mr. Samboy, one of the things that is the difference between when you're representing a corporation versus an individual. I think that is like one of the biggest things, and I think family lawyers deal with this probably all the time. What do you do?
So I have parents come into my consultations constantly.
Okay.
And there's a fine balance because while I have the privilege of client selection now, I still want certain clients that will pay my fees. So allowing dad to participate in that initial consult has to be done with, we have now a scripted disclosure that we provide to our clients. We give them some horror stories. That question that is asked often, who was present in those consultations, happens constantly in family law trials.
Okay.
And it does create privilege issues. But also it's family law. We have so many, there are certain things that are really important to protect, and privilege is really important. But also it's family law, and everything comes out at the end. So nobody's really necessary to further a family law dispute outside of that particular litigant. So we give them the disclosures, we have a scripted informed consent that we have people sign if they want to have mom, dad, sister participate. And so far hasn't been an issue.
Do any criminal practitioners do something similar? Okay.
But that sounds like a very reasonable approach because you're dealing with what the client wants and you're giving the client the education so that Sidra doesn't have to represent you in a malpractice case if something happens in the future. So.
That's all it is. I give them the horror stories, they sign
Yeah.
yeah.
I actually have kind of a question for the other panelists on their thoughts on this issue is, what are your thoughts on having the spouse, especially in spouse situations, a lot of times the spouse will be directly impacted by the result of the litigation or whatever it is. What are your thoughts on having both spouses on the representation agreement?
I guess it depends on what the subject matter is, right? So are they reasonably the client, right? So in my situation, if I'm representing a lawyer or a law firm, the spouse is not a lawyer. I mean, they can't be my client. It just doesn't, it doesn't fit in. I think that would be an argument that I would not want to put forth in a motion. I would, or in an opposition to a motion. I wouldn't reasonably be able to say under my Rule 11 obligations that they were my client because they were not my client. But maybe in other situations it might be appropriate.
And sorry, I was going to say the reason why I raised this point is because I've definitely had clients where their spouses have wanted to be on the representation agreement because of the financial impact on them of the litigation. So I'm curious to know if you have thoughts on this.
Well, so the second paragraph of my engagement agreement, when I started my private practice 21 years ago, after the career in public service, my engagement agreement was like 3 pages long. And then you experience, horror after horror after horror, and now it's probably 8 or 9 pages long, with headings and subheadings. The second paragraph defines who the client is. The second paragraph says, you are the client. We represent none of your family members, none of your corporations, none of your subsidiaries. We represent none of these people. Now, as a practical matter, as the reasons you raise, and sometimes it's not just that the spouse, it's going to have a financial impact on them. It's that the actual client needs to have their spouse involved in the decision making. That's just a core need they have. And so an example of this is I have a mediation coming up at the end of next week where the client is going to have his spouse there. Now, that's okay because everything is going to be covered by mediation privilege, right? But nevertheless, in every key decision, the spouse has to be involved in those conversations because my client just isn't able to function without having his spouse involved in the decision making. And it creates issues, but they're issues I'm winding up having to live with in many representations because of the importance of that person for the decision making for the family.
To follow up on that point, I think it's a really important one for, I don't know if other practitioners experience this, but oftentimes my client's spouse or family member will get deposed, have a business subpoena sent to their office, and our retainer does say, your family members are not our clients. And we now have a list of trusted referrals for those family members to defend them in a depo or handle the subpoena, because we will not defend the spouse's deposition. We think conflict. So we put it into our retainer now, and we have a list of referrals for that.
Thank you.
Should we move to the next?
Sure.
Just very quickly, from my perspective, the issue of having who the client is defined in your engagement letters is critical. So from our perspective, like expert witness work, that's really important to us. But also, in everything we do, in the back of our minds, we assume that anything, our work product could be discovered. So while there is privilege, and we try and maintain that privilege as, right, in the back of our minds when we're doing, our investigations, our expert witness work, we really do, we're risk averse, right? So we are thinking that this stuff could be produced. Any of it could be produced. And so I'd like in the thing, I want to make sure we cover all 4 hypotheticals. I love the conversation that's happening. So I think I'm going to move on to the third one. So a child gets severely injured during a Diwali event at a local South Asian community center. The family is now suing the nonprofit. You're a litigator who regularly attends the center. At the dinner party, several board members, all uncles you've known for years, pull you aside and ask, you're a lawyer, and you know us. How do we make this lawsuit go away? So I am going to ask our esteemed judge on the panel to kick this conversation off.
So the first thing, obviously, I would be scared of is, am I creating an attorney-client relationship with this person? They're asking essentially for legal advice. That's how I'd interpret it. And so you've got to be mindful of, there's a whole host of rules. Are you creating attorney, so 1.2, 1.6, 1.8, I mean, it's a whole, there's a conflict. There's all sorts of things going on because, and this was so I think the easy, if this was a law school exam, the first thing is like, oh, be careful of creating attorney-client privilege. That's the easy one, right? Everybody sees that. The second one is, I think there's the concurrent conflict potentially because you attend the place. You go to this place. Now that's a little more, it's a little more subtle. And so what creates a concurrent conflict, if we can go to the next slide. So the part that scares me the most is this: a concurrent conflict exists if, one, representation of one client is directly adverse to another client, okay, fine. Or there's significant risk that representation of one of our clients will be materially limited by a lawyer's duty to another client, a former client, or a third person, or by the lawyer's personal interest. Like that phrase to me, or by the lawyer's personal interest, can cause some harm, because if you attend this place, you have a relationship. Is that in your interest? Is that in your personal interest? That is a really problematic phrase. And I'd see these problems, and I'll confess, I used to practice civil law, then I did criminal, then I went back to civil. And after I did criminal law and went back to civil, I saw concurrent conflicts everywhere. And I would go into depositions and I would get yelled at. Let's say a company is there defending, a lawyer for the big firm defending the company. They have the engineer there testifying. I would say, Ms. Doe, who's your attorney today? And the big firm attorney would be like, well, I'm their attorney. It's like, who's your attorney today? And what I'm trying to say is like, this person's not your attorney. This person is the corporation's attorney. And so that's the concurrent interest, and they would get, most big firm people would get so pissed. Like, what do you mean? You're trying to drive wedges? Like, do you have a separate engagement letter with them? Because in the criminal world, and in the family law world, we're very mindful of, you get counsel for everybody, and then you enter into a joint defense agreement. They don't do that in the civil world very commonly, especially when they're representing one company. And they oftentimes, that person who's being deposed doesn't know that the attorney's obligations are to the corporation, not to them. And that's the first time they're hearing it. And I used to love that when I was taking, and they're like, okay, you're not my attorney. You know, it dawns on them for the first time. And concurrent conflict is where I think in big firms, they're very loosey-goosey with this. I mean, so just be mindful of that. And then when representation is allowed, you just have to give disclosure. That's the big thing. You can represent two people. You just have to, both folks have to understand, and I've always been uncomfortable with this. It's like, at some point, there's going to be a Hobson's choice. Like, okay, in a case where there's a wire fraud allegation where the wife and the husband were both at control of the bank, like, okay, who am I going to save? That's hard. That's a hard thing, and so my approach was just don't do it. So just be mindful of the concurrent representation issues and the phrase that used to freak me out was, or by the lawyer's personal interest, because that God knows what that means. And then last thing I want is somebody from the state bar calling me about that. So, yeah.
Sorry to keep that.
Sure.
I'm curious about the non-litigation setting, because as I go back to that hypothetical, right, and later on there's going to be a panel on how we lift each other up and develop business by developing communities, whatever. Like, I can imagine people looking at someone, wait, but that's actually a referral source, right? If
Yeah.
you're within my area of practice and somebody says, hey, I need help from you in your area of expertise, I'm like, I feel like there's a sense of like, this is how everybody does it, right? Everybody goes to their country club or their religious community or whatever, like that is where else would you find people? They're not going to show up in your Zoom room to hire you. So like in a non-adversarial setting for a transactional attorney or like a small business attorney, like where's that line of, it is actually okay for me to get business through the uncles or the elders or the whoever it might be.
Yeah, I think, right?
Yeah, there's nothing wrong here with helping them, but there's a potential conflict. So I think what the slide here talks about the exceptions. You can get informed consent, but there's also like Rule 1.13. Who represents who are the representatives or the organizations that you're going to like deal with? So these are, we're having these very colorful hypotheticals, which are in real life for many people, but they're just kind of warnings. Every one of these, there's a way out. And, let's say in the immigration one or the family law one, you were competent. You could still do those. You just got to set boundaries. And I think that's maybe the purpose. If you were to ask me what was the purpose of the CLE, is just to have a fun conversation about difficult situations that we are in dealing with non-clients, but also with clients, and maybe things that we can do to try to alleviate those situations. Can't obviously prevent them, and we're not saying just say no completely, but how do we deal with these problems? And I think in this situation, you do want to get those referrals, and you may want to say something like, hey, why don't we set up a time and get a formal conversation going, because I do need to talk about conflicts. We need to just explain those things, because before you really get my advice, I want to make sure that you know the good, the bad, the ugly, and the four corners of the case, and let's sit down and properly do it.
I just had kind of one point to add on the organizational clients that the judge mentioned. I think it's really, really important to kind of always keep in mind who your client is. I've actually seen situations where I've had attorney clients that represented, a board of directors of an organization, and they kind of assumed that the conversations that they had or communications they had with either employees of the organization were also privileged, and then those communications were later subpoenaed, and it turned out that they were not privileged. So it's really important to keep in mind, who the actual client is, and really kind of at the beginning of the case, when you're dealing with this kind of complex situation, I would kind of take mental note of, this is who I'm representing, this is who the privilege is with, everything else might not be privileged.
So in the Ninth Circuit, criminal lawyers will do what are called upjohn warnings. And it's very common. And in the Ninth Circuit, the big case was Ruhle, Ruehle, and that involved privilege of the CFO in that case, who was interviewed by corporate counsel, and whether that constituted attorney-client privilege communication. So, again, criminal attorneys are much more, I think, cognizant of this. And civil attorneys oftentimes will go, I did this. I used to go interview when hey, go interview 4 people at the company about when this invention was created. It's like, okay, I go in and interview them, and nobody really it's sort of this detente. Nobody really raises the thing because, I'll start asking you what you asked your people about too. So it's a touchy area. Just be mindful of it, and then you'll take your steps appropriately.
Yeah, I think really it's an issue of client management and thinking ahead a little bit. And sometimes these situations are very fluid. You may be retained to represent the board. You find out something, and now you're like, okay, we have another issue. while the CEO is on the board, the CEO is now maybe going to get investigated for something, and so now you've got that dilemma. But some of it is, in my mind at least, the communication, having communication with your client constantly to kind of explain the situation. Because if something comes out of left field, that will start unnerving them a lot. I think we had one more question on this, and then I'd like to kind of go to the fourth hypothetical. There was a... Yeah.
The example you gave of when you ask the witness the question of who your attorney is, from your perspective in that decision, what is the advantage you're hoping to gain? Are you saying that there isn't an attorney-client privilege, or you kind of ask for this communication for that attorney that was in the courtroom at that time?
Yes.
That was allowed.
I mean, well, so what part of it is what it's going to be. It's like down the road when you're asking that question, their client or the attorney is going to sometimes instruct their client to not answer based on attorney-client privilege, and you're asking that witness, are you following the corporation's counsel's advice? Right? It's not, are you following your attorney's advice? Because they're not your attorney. And they then, and so part of it is sometimes, some would call it gamesmanship. I think it's like, hey, this person is not your attorney. Are you taking this person's attorney's advice on telling you not to answer something to me? And they'll then explain, well, that's the corporation's privilege, that's not your privilege, and things of that nature. But it can it creates that little space where sometimes you can get some really good information.
So this theory that a lot of this happens in the employment law context more than like Littler, Jackson Lewis, all these firms, they use it. It's called the accommodation client argument. It's not recognized in every jurisdiction, but it's this idea that we are corporate counsel, outside counsel to the firm, and by virtue of you, like in an employment dispute, being also sued and named in that lawsuit for harassment or whatever, as an accommodation to your employer, we will represent you. And that's their way of trying to get around a typical conflict waiver, because in a typical conflict waiver, you would, if you had like let's say during the investigation they found that you had engaged in some sort of harassment and you need to be fired. Well, now you have confidences of both sides and you would want to withdraw from both. So in this case, they'd say as an accommodation, we will represent you, but if we have a conflict, we will only withdraw from you. But not many lawyers are familiar with that, so they won't make that argument. They'll just be stuck. And
Is there a separate engagement letter with that client?
You know, many big firms fail to get engagement letters in general.
Okay.
I just want to offer this quick, before we move to the next hypothetical, I want to offer this quick cynical point from a plaintiff's civil rights lawyer's perspective. Look, I mean, everything the judge just said about these concurrent conflicts is 100% correct, and yet for some reason, the federal judiciary doesn't care about it in the civil context the way they do in the criminal context. Well, I raised it. I raised it. Hold on. Let me finish my story, Sir, Your Honor.
I'm not Sir, Your Honor. Now it's just
all right. Now, in the criminal context, and I'm a former federal prosecutor, no federal judge would tolerate the concurrent representation of two people who could be in conflict. I've had civil, First Amendment retaliation case involving employment where the public entity, the lawyer for the public entity, insurance defense counsel, it's always that, right? Globally claiming to represent everybody, including key witnesses, who are all pointing the finger at each other for who did the bad stuff. I've got them, right? So I send a letter over to opposing counsel saying, look, you've got a conflict here. Please address the conflict. You can't represent everybody. Basically, the response is screw you. Then we file a motion to disqualify. It takes a year to decide. A U.S. magistrate judge agrees with us, says there's a conflict here. You can't jointly represent everybody. And then that goes to the Article 3 judge, who then, because they now belatedly produced the conflict waiver, which was so unwaivable, right, factually. They're literally pointing to each other on the core issue in the case. And the Article 3 judge says, fine. So, and then, we get blowback and complaints about how dare we disrupt this litigation with these motions. So I just think that culturally, there is a tolerance by the judiciary of corporate and insurance defense conflicts. It's just indulged, it's considered normal, and it's all wrong according to the rules. And yet, even though there's no difference between the impact of that conflict in criminal versus civil. It's just a part of our culture, and we're all supposed to just take it.
Thank you. I really love the lively debate.
Yes.
I hope, yeah,
Take that, Your Honor.
yeah.
Look, I wish it was raised more, and I like the fact that you put it on the DJ, not me. It's like I got the ruling out quickly. Thank you.
So I'm gonna move quickly to hypothetical 4. We have 10 minutes left between the ending of this panel and your lunch. But if you'd like to stay, I'm sure our panelists would like to as well. But let me move quickly to hypothetical 4. An older family friend corners you. Better, I'm being sued for financial fraud and failure of fiduciary duties. Something close to my heart, which is something, this is actually has happened to me since I investigate this kind of stuff. I only joined the board because my school friend from Delhi asked me to. Look, you've known me since you were in diapers. Tell me what I'm supposed to do. Obviously, if I have to formally retain you, you'll give me a family rate, right? So, Subodh, I'll ask you to tackle this one and also kind of raise the issue of trial publicity, if you could.
Okay. So, my first response would be, by the way, there are rules in some states about you can't even use the word discount, right, when you're referring to your fees. And so you just got to be really, really wary about that. I'm sure Emil could shed light on that, but it's just simply this is the rate that we charge, this is the rate that we charge. And if you have as part of your formal structure that there are certain preferred rates, you can say that. But on that rate issue, forget about it. This is the rate that we charge. One of the reasons, by the way, from a plaintiff's law firm perspective, and we do some white-collar defense work, in this situation, I would also be explaining to the potential client, I have to charge the same rate to clients because we also file fee petitions and we have to tell courts that this is our standard rate. Otherwise, all of the previous discussion applies. You're going to make sure, you're going to say, okay, first I have to check to make sure my firm doesn't have a conflict. Please give me the names of all the people involved. Let's not get too deeply into the facts. But let's say this winds up being a high-profile matter, which is turning us now to Rule 3.6, which is the rule on, it says trial publicity, but it's really about publicity throughout litigation. This is an issue I've taught seminars on, and what I would say to you is, people don't really study this rule as much as they should, because the first part of the rule creates this very ambiguous, seemingly subjective statement that says a lawyer who is or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be publicly disseminated and will have a substantial, this is now a high bar, but still subjective, a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. So substantial likelihood of materially prejudicing. What does that mean? Your guess is as good as mine. But what I would suggest to you is few people then look beyond it to Rules 3.6b and c. And when you look at Rule 3.6b and c, it says, notwithstanding the general rule. Now you can go search your dictionary and thesaurus for what notwithstanding means. It literally means forget everything I just told you above, right? Forget everything. Despite that, even if it would have a substantial likelihood of materially prejudicing an adjudicative proceeding, you may do the following. And those things are about public records, court records, a call for assistance in the investigation, the scheduling of results of litigation steps. You can tell, hey, there's going to be a trial coming up. There's going to be a hearing coming up. You can say that to the media. I actually saw a lawyer was sanctioned for doing that, for just telling a reporter that there was going to be a trial in the matter, and that was reversed by the Court of Appeals because it was just wrong. That judge, by the way, had learned the rules long before the law had changed and long before this rule had come into effect, and there was no briefing that was going to convince him otherwise. warnings of danger or substantial harm. In criminal cases, there's certain information you can provide. But again, public record information, claims, defenses, there's a lot you can say. Now, why am I bringing this up? It's because a key part of our job as lawyers, particularly in these high-profile matters or where your client could involuntarily be drawn into a high-profile matter, and it sounds like in our hypothetical that could be the case, a key part of our jobs, courts have recognized, the U.S. Supreme Court has recognized, is about the reputational protection of the client. It's not just about the adjudication. It's not just about the court activity, but it's about protecting the client's reputation. And so Part C in this, 3.6C, talks about our ability to respond to things that the other side has put out. So say if it's the prosecution and then they've put out a statement, you're permitted to react to that to try to mitigate the reputational harm. In the Supreme Court's, I don't know if it's Gentile or Gentile, but Gentile, that was a case where a lawyer was severely sanctioned for statements, and the Supreme Court took a more First Amendment protective approach and reversed that sanction, and then Rule 3.6 evolved as a result of it. So keep in mind there are things you can do. If you are interested in learning the exceptions to Rule 3.6, you can search my name, Subodh Chandra, Ethics Singing on YouTube, and you will find me singing to the 12 Days of Christmas, all of the exceptions to Rule 3.6.
Can we get a little bit now? Just kidding, just kidding.
Yeah, no, I don't think so.
Is there just a list somewhere?
Yeah, the list is in the rule. But if you want to hear it to song,
Yeah.
right, we list all of the exceptions so that you can remember them. But this is really important because I think that few people really seem to understand that our jobs as advocates are, and judges can sometimes bristle at this, right? They don't want, some judges are sort of more, don't say anything about my matter, and they issue unconstitutional gag orders, and they are unconstitutional if you look at the case law. They can be overbroad, they can be unconstitutional. But at the end of the day, ethically, we are permitted to protect the client's reputation, and these exceptions are baked into the rule.
Can I just ask one question, particularly on these high-profile cases? Sometimes there's a kind of PR crisis management firm that is specifically hired. How do you work with them in relation to Rule 3.6?
Well, typically I'm the one making their lives miserable, right? But no, there have been times where we've been working in coordination with them. And again, we will scrutinize any statements that they're putting out. I am wary about those communications because I think the work product and privilege associated with those communications is ambiguous. There are some courts that are protective of that and say, no, that again, that's legitimate lawyer work, and therefore it's attorney work product, and no, you don't have to reveal that. There are other courts that say, nope, sorry, that had nothing to do with lawyering. They're wrong about that, but that's what they say. And so then those communications can be revealed. I do seek that if I'm on the attack as a plaintiff, and there's some big PR firm, Dixon Eaton or one of the big national PR firms has been hired to protect the big institution, and they're putting out all kinds of attacks on me as a lawyer, and they're putting out attacks on my client. Then I will, lay in wait, and then in discovery, hey, I want all the communications that were happening because I want to see what efforts were made to mislead the public relations firm about the underlying facts that we can then leverage for punitive damages purposes or other purposes, maybe even, add a defamation claim to our suit. So it does come up, but the best crisis communications folks, and we do some of this work ourselves, their advice is tell the truth, tell it first, tell it all. Now, they don't always get the full cooperation and understanding from their client on that, but those are the 3 bits of advice that they give. So if you're putting out a bunch of dumb statements and then the facts wind up proving otherwise later, it can really blow back.
Yeah, and I think particularly on the issues of financial fraud in particular, that's exactly what we would tell our clients. Like, if we're doing audit malpractice or even legal malpractice that may lead to something high profile, it's like, don't keep communicating.
Right.
Say it once, let the work, let us finish our work, whether it's damages or whatever it is, let us finish, and just one communication and that's it.
Right.
I don't know if there is anyone else on the panel, Your Honor, if you'd like to add.
We're at 12.
I know we're at 12. Spoken like a true judge.
Lunchtime.
I don't know if there's, I guess we might have a couple of minutes, just a couple for questions on this potential hypothetical, if there are any out there. No?
Thank you, it was excellent.
Thank you.
Thank you.
Thank you so much.